Good evening.
Tonight, opening statements in the trial we've been following and a same-day hearing that could shape what happens to two brothers fighting extradition. This is the particulars. It is Monday night. I believe today is July 27th.
Something like that. They all run together now.
This is episode 10. Welcome back. I'm Lacey. I run a licensed PI firm, and I'm a law student.
I'm Nick. Everything tonight is our opinion and analysis based on the public record. We are not attorneys, and nothing here is legal advice. Everything verified as of 5:30 Eastern.
Quick reminder for anyone just joining. Lindsay Clancy is on trial for the deaths of her 3 children. She's never disputed that she caused their deaths. The entire fight is over her mental state under Massachusetts' lack of criminal responsibility standard, the formal name for what people usually call an insanity defense. It asks whether, because of a mental disease or defect, she lacked the substantial capacity to appreciate that what she was doing was wrong or to conform her conduct to the requirements of law.
And once that sufficiency raised, the Commonwealth has to prove beyond reasonable doubt that she was criminally responsible. Both that she had the capacity to appreciate the wrongfulness of her conduct and the capacity to conform her conduct to the law. The defense doesn't have to prove she lacked that.
Prosecutor Buckingham told the jury the children were deliberately and meticulously killed, a calculated decision, not a mental health referendum. Defense attorney Kevin Reddington didn't dispute that Lindsay Clancy caused the deaths. His argument is that she was over-medicated and in extreme postpartum psychosis. Patrick Clancy was called as the prosecution's first witness and testified today. Now, I will also say that in terms of this case and this trial, different media is reporting things as far as day count. And you will see this, it's pretty standard across any trial watch that you will see, like, court TV, things like that do like minute by minute. A lot of times how they count their days is different. So for us and purposes of the trial, we are calling this day 1, meaning when the opening statements took place today, I count that as day 1. So just all of that to say, day 1 has now concluded, and Patrick is scheduled or planned to return to the stand Wednesday when the trial resumes.
Much of today's testimony centered on Lindsay's medications in the months before the killings. Patrick testified she was prescribed several drugs for anxiety and depression, and that's where things took a turn after she started Seroquel. He called that period the start of her big spiral.
The prosecution's approach was notable here. They weren't hiding the prescriptions, they were using them. Prosecutor Jennifer Sprague introduced a bag of prescription pills into evidence, pointing out that while a lot was prescribed, many of the bottles were still largely full, arguing Lindsay wasn't actually taking most of what she'd been given.
3 of the counts of strangulation or suffocation were formally dismissed on July 8th and 9th per the docket itself. That's a change to what she's currently charged with. And we want you to have it accurately. The murder charges remain. These 3 additional counts of strangulation or suffocation do not. This is the kind of discussion, we've been looking for.
Again, we've talked about this in other episodes. My news feed, due to the fact that I spend a lot of time in research and things like that, and I'm looking at
targeted
cases, my news feed, even my searches, everything is very targeted. I want to know, did anyone have anything from the trial day to day on their timelines? Has anyone seen that yet?
Specifically with
the
Clancy case.
The Clancy case is what I'm asking about. I'm wondering if anyone has seen any of the coverage so far. Well, there is a picture of prosecution side. And I call it, again, this is my scroll through, just flipping. Actually, I'm get rid of my notifications on my phone because it drives me crazy. So I'm going through, cleaning things out on my phone. And, you have your pictures. Of course, you have all of your news reporting on top of the pictures. But there's a picture of which would be the Commonwealth. And she is holding this bag. I say it's like a gallon Ziploc bag, you know? And my first thing is I'm thinking, first of all, now we are a little bit older. And every Sunday we have the little 7-day pill things. Nick and I do. And so every Sunday we take our stuff out of the cabinet and we sit there and fill them all up. And as we get older, more and more gets added. Okay. And I'm thinking, when at first, honest to gosh, when I look at this bag of medicine that she's holding, I'm thinking in my head, I'm not trying to say,
oh, it's a gallon bag full of medicine. I didn't see that.
Yes, it's a bag of medicine. And they're all technically, they look to be at first glance prescription medication. However, different pharmacies have different bottles. So
yeah, and if you emptied our medicine cabinet,
there's probably a lot in there.
Good Lord.
What I will say also, and I'm going to bring this up because this was one of the things, again, I was getting snippets of things in my quick glance. I kept seeing, and we talked about it, when they said that many of the bottles were still largely full. So I will go out on a limb and speak to some of my own personal testimony, lived experience, if you will. So I struggle with obsessive compulsive disorder and general anxiety disorder. Okay. So I think I got diagnosed at 21, 22. Over the course of time, they've tried multiple medications, which is standard for anyone that has any kind of anxiety, depression, any of those things. They start with again, this is my lived experience. They start with one. When that one maybe has the side effects are too much, or the patient doesn't like those side effects, they'll switch. So to me, when I see, a bag full of medication, I'm not instantly thinking anything negative. I'm thinking, okay, that shows they've tried several different medications. And according to my own lived experience, when they switch from one to the other, you don't continue to take it. You discontinue use of what you were on and they switch you to something else. That's kind of, same with an antibiotic. If you're on an antibiotic, if you're having some kind of issue, sometimes they discontinue it and give you another one. So stating that the bags were, in my opinion, when we see, a bag of pills and the pills are largely there, where I think what they were trying to say is that she wasn't taking them.
Yeah.
I don't see it as that way. Again, I try to look at things from a lot of different perspectives.
We went into pretty good detail about what we think as far as this trial, but for me specifically, and again, this is my opinion, it's going to be a difficult case for the prosecution. It is, honestly, because of the dependency and the history that she had with mental health.
I do agree with that, because I think, in all honesty,
but
my perspective on that is somebody that wasn't actively trying to get help.
Here's the problem. Someone who is constantly actively trying to get help is sane. Someone who is not has a better chance.
Okay.
That's my opinion.
I'm going to say not necessarily.
Because you have a track record of trying to get help.
Yes, but in my opinion, for someone to seek out help, they realize, 12 steps. They admit they have a problem.
Absolutely.
They are trying to.
But it takes a sane mind to do that. And that's what the state is trying to prove, that she had the wherewithal to commit these crimes. And if you have that state of mind.
She was a labor and delivery nurse. So again, they've had that a little more, more knowledge than the lay person.
Yeah, so, especially with postpartum depression.
And again, speaking from my opinion, I am not any kind of medical expert,
right?
But I have had 2 children.
Yeah.
And again, every time I went after having both of the children, every appointment, they ask those questions.
Yep, because it's a prevalent thing.
So, and again, I don't want to overstate or simply state in any way, because I don't know specific. I was not in the room. I don't know her mindset, if she was answering questions.
Right. And that's going to be up to her defense attorneys
Right.
to present that. And like I said, it's going to be tough both ways.
Yeah,
and that's why I believe
know you think it's gonna take a while.
6 to 8 weeks of a court case, I don't think is going to touch it.
I do think they're moving along well. Again,
well,
opening statements today, and then Patrick. But I also want to say that this is a very heavy day. So I'm not speaking for the judge. I'm not speaking for any parties of this, but I have a feeling that you may see a slower pace at some things just because we are taking, the jury who was sitting there. And again, they are hearing the 911 call.
Right.
They are seeing the photos. They are hearing the testimonies. And I think that that's going to be a very heavy weight that the jury is placed under. So I think that may... That's
where it's going to slow down.
I think it's going to kind of... I think that the judge may say, okay, we'll recess at this time and pick back up tomorrow or whatever. I think, again, I just can see some of that happening as it plays out. But because I think it's a very hard case in any way, shape, or form that you look at it. I think it's a very hard case.
So this has been the Trial Watch?
Yes, it has. And with that, before we move on to our next segment, does anyone have any discussion, questions, anything in regard to the Clancy trial that is going on? Anything, if you watched, that you would like to share or that you want to discuss?
We're going to set up the legal minute later tonight without giving it away, but...
I think you already did.
No.
Okay.
So the Tate brothers, I love talking about them.
You're going to be nice.
So confirmed to be reportable, U.S. Magistrate Judge Lauren Luis ruled today that Andrew and Tristan Tate remain in custody at least 2 more weeks, setting a detention hearing for August 13th to decide whether...
That is such a very exciting day, is all I'm going to say.
Word.
I feel like
to decide whether...
There's a lot going on in court on August 13th.
They stay jailed or are released while extradition proceedings continue. Neither brother was required to attend today's hearing. Obviously, just their attorneys appeared.
Everything we've got lives in one place, our link tree, okay? So the link is in our bio. Our schedule, our coffee. If we're saying that wrong, could someone please say, hey, it's Ko-fi?
Yeah, it's KO-FI. I've never heard of this. I guess it's something that...
But coffee makes sense because if
they
you go to the
coffee
site,
and mugs
they're
and
like,
stuff.
this, you can tip this person and buy 5 coffees or whatever.
Yeah,
so it literally shows a coffee mug. So to me,
it's probably
coffee makes sense.
Yeah.
If that's wrong,
oh well.
At this point, it is what it is, right? But anyways.
Well, I will say there have been no store or purchase updates tonight.
Since our last live.
Friday.
So our Sticker Mule store is up. So if you would like to buy our 2 brand new stickers, we have one for the particulars, and then we also have the Casewalker Chronicles. And we have some pretty fantastic t-shirts. And I got a notification, my shirt has shipped. I do believe I'm supposed to get it July 29th.
Awesome. All right, ladies and gentlemen, we are moving on to
the legal minute. Where's our thing? Thank you. I enjoy that.
Thank you all. If you're just joining, we are in segment 2 of the podcast right now for tonight. This is the legal minute.
The legal minute.
What opening statements actually are and aren't.
This one I am super excited about. This is going to show a little bit of the nerdiness coming out, all right?
We're all nerds.
The Massachusetts Guide to Evidence spells this out directly. Section 1113. Quote, the proper function of an opening statement is to outline in a general way the nature of the case that a party expects to be able to prove or support by admissible evidence. The expectation must be reasonable and grounded in good faith. Argument for or against either party is not permitted, end quote.
Yeah, and there's a real consequence if a side oversells it. In the same section, if what's outlined in an opening statement is, quote, plainly insufficient as a matter of law, end quote, to sustain that party's case, the court can direct a verdict against them.
This is Superior Court, so there's also a hard time limit. Rule 7 caps opening statements at 15 minutes unless the court extends it for cause.
Right, and here's the actual line the juries hear from the judge, word for word, from the Commonwealth's own model jury instructions. Quote, the opening statements of the attorneys are not evidence, end quote.
So whatever you heard this morning, that's the map, not the territory. The evidence is what comes next.
What they're trying to do with opening statements is tell a story.
I was going to say they're putting their narrative
It's
out.
a story. It's a narrative, which is a story. They're telling their story of the case. And believe you me, it is going to have everything to do to go against the other party. Everything in it is going to go against the other party. They're not going to have anything in their story that helps the other party. That's the way they frame it. Stuff will get left out. Stuff will be embellished.
Well,
it's not evidence because it can't be used as evidence. They can tell a story, and that's what happens.
I'm just going to say, I feel like when we've discussed this, and again, I none of our episodes kind of build other than the trial watch, but what I will say, we've talked about it a little bit before. And because people have asked some questions like, what kind of evidence or what would make it inadmissible, things like that. You know, some of that is where it gets really tricky because you have each side kind of competing. And I think Nick had talked about it at one point as like a game. And that makes sense because it's like this team doesn't want this team to win or their side to seem more plausible than this side.
So they're going to play this
It's the
play.
give and take. It's a dance. So we'll call it a dance. That sounds a little nicer. But it's a dance between, you know, one side versus the other because they want their story to be believed. They basically, the other side, the defense, basically just want you to have doubt.
Right. And understand that with tonight's legal minute, we try to keep it short. That's why it's called the legal minute. But we do want to emphasize that with our legal minute, the opening statements of the attorneys are not evidence. So they can't be used as evidence in the framing for the jury on their decision. All it is a story to help them understand the evidence that they are going to be presenting.
So the opening statement, in my honest opinion, the opening statement is like us. Okay, we're going to sit here and we're going to tell you something. Now, we're just talking to you.
Right.
But what comes next through the witness testimonies and things like that, that's the presentation of
and that's
evidence.
how you interpret it.
And so we're trying to say that this evidence proves what we stated.
Yes.
To make it seem like that is the fact. And then the defense.
And understand that the prosecution
Well, it's a
always
Commonwealth.
goes first.
You keep going prosecution. It's
I'm
Commonwealth.
sorry.
It's a little bit different. We need to cover that at some point.
In Massachusetts, for this instance,
It is the Commonwealth.
Yes, it is. And that's what we were talking about. And their framing is, and their model is that. But the Commonwealth or the state or the prosecution in criminal cases always gets to go first.
Yes.
Always. Because they have the burden of proof.
Evidence.
This is a good one.
This, my friends, is going to be one of the most... So Nick and I have been married for a hot minute, okay? And we have difference of opinions.
You keep flip-flopping, though. Come
No, I
on.
don't.
Come on. We were on the same page when this all started, and then now you're like, oh, well... Look at this.
I will say that I was leaning one way before all of this.
Yeah. You're going to make some enemies.
You know what? At this point, I feel like I'm making them every day. It is what it is.
Every day.
Evidence of the night. 1 year after pleading guilty to murdering 4 University of Idaho students, Bryan Kohberger is trying to take that plea back. Multiple outlets citing court filings report he filed a petition for post-conviction relief today in Ada County District Court, case number CR01-24-31665. The same case where Judge Stephen Hippler accepted his guilty plea on July 2nd, 2025, and sentenced him to 4 consecutive life sentences without parole on July 23rd, 2025.
Now, post-conviction relief is a separate thing from a direct appeal.
Yes.
It's a way to challenge a conviction outside of the normal appeals process, usually on grounds like ineffectiveness or ineffective counsel or newly discovered evidence. Kohberger is currently representing himself on this filing, which is wild.
In a statement to the New York Times, Kohberger said his plea was, quote, hinged on by false promises and blatant disinformation, end quote, and that his actual innocence, quote, must, end quote, be recognized. Reporting citing sources familiar with the filing says he's arguing ineffective assistance of counsel, that his defense team didn't disclose certain exculpatory material before he pleaded.
Now, before I read this, I'm going to say my opinion. His defense attorney told him he was going to make a lot of money off writing a book, and he didn't make a lot of money. So he's got to tackle this shit again.
I will tell you that when I got home today, my friends, I went down a rabbit hole.
All right, so
searching for this document because I wanted to see the filing myself.
Idaho's legal standard for this is pretty high. Courts can only set aside a conviction to correct manifest injustice. That's the quote. That's a real bar to clear when it comes to the legal system, not just changing your mind after the fact.
If you are in the United States and you've never heard of this case,
right?
This was a wild case, and I will tell you that from the beginning, I thought it was very, very interesting because he was a PhD student, I believe.
In criminology.
So.
And a teacher's assistant.
In my personal opinion, I feel like he was very involved in his case.
Mm-hmm.
So if in theory he were trying to say like ineffectiveness of counsel,
he would be able to articulate it better than a layperson would.
So that he is now, from what we are seeing coming out today, potentially filing on his own without counsel.
Yeah.
The mind of that individual to me is quite fascinating because as someone who has lived through that trial and has that knowledge from post-high school education in some of these areas, I just think that's very interesting. It literally piqued my interest. So I don't know. You know, I have not seen the actual petition.
Mm-hmm.
I searched.
Our docket pool was dated before today's filing, so we haven't read the petition itself. That's sourced to NYT, CNN, Fox Reporting only.
Which, on that note, can I just throw something in? Can I just throw this in?
Sure.
Do you know what really irritates me when it comes to media?
Oh, we'll tell you this, but you can't look at it.
No, here's what I think is really, really frustrating, okay? We've got these news people, okay, that come out and they're like, ooh, look what just happened today. But take my word for it because it's nowhere to be found.
Yeah,
Only we have this information.
Well, I mean, it's a source that they have, and they're not going to give it up.
Incorrect. I'm just going to throw this out, okay? This is my thing that I'm saying to all of the people out there. If you see something that a news station, media, anything like that is reporting and you cannot verify yourself, that's a red flag to me. That is not a red flag here. I'm just saying that's one of my red flags because why can't I verify what you said?
Yeah.
Why can I not see the document that you see as a public citizen? You don't get. It's not like that game where, oh, you're younger, we're going to give you a head start. That's not the way this works. You don't get a head start.
Okay, it's kind of what this podcast is about. And I'll go ahead and say it. The mass media is controlled by a certain organization and different
political parties.
And that organization
organization
does not want an educated populace.
Oh, I don't think anybody wants us
because
educated.
that is bad for them. But I'll digress on that because that's a whole different type of podcast.
Yeah, and we don't do politics.
That's right. The Goncalves family.
Yeah, they released a statement.
What'd they say?
They didn't hold back.
I know.
In a statement, they called Kohberger's supporters and this filing, quote, the mosquito you just can't seem to swat, end quote, and pointed out that when he pleaded guilty, he told the judge himself that his plea was knowing, voluntary, and intelligent. Their statement was long. I thought, which they are very, very big advocates. They are doing a lot. I understand. And please don't come at me that I am not supportive of the victims in this case. I think what happened was absolutely horrendous.
Yeah.
However, I am a very big constitutional person. And there are a lot of cases in our country, not that this is one, I'm not stating that. What I'm saying is there are a lot of cases in this country where there are truly innocent people that are in prison.
Yeah.
That is why we have organizations such as the Innocence Project.
Mm-hmm. I don't think they're going to touch this with a 10-foot pole, though.
I'm just saying. I'm just saying that in theory, you have heard me say it multiple times. Anything should be able to uphold after scrutiny.
Mm-hmm.
So if it is truly he was guilty, and yes, it was proven, he was convicted. However, it should.
He was convicted on a guilty plea, not a trial of his jury of his peers, though. That's different.
We're not going there.
That's fine.
All I'm saying, okay,
mm-hmm.
I know everybody's going to come at me for this. It is what it is. I'm just saying.
The Attorney General of Idaho, Attorney General Labrador, has already responded publicly saying his office is ready to do whatever's necessary to see justice is carried out. Worth what it is, so.
Justice is a very interesting word. I'm just going to say.
Yeah.
Because, I'm just going to say this. If you are, so to speak, pro-victim, justice in your eyes is that the victim sees justice. If you are like a defense, like you're pro-defense, you're going to say justice to you is a defendant being proven innocent if they are truly innocent.
Mm-hmm.
And if you are from like a prosecutor side, you're going to say, well, we upheld the law. The person that violated the law was guilty. That is justice.
Yeah.
So what I'm telling you is when you see people throw things out like justice, understand that depending on which side, justice does not look the same for each of those, all of those parties. Justice means something different. And quite honestly, in the terms of this, those 4 lives are gone. They can never be brought back. So for them, there really is no justice because they're gone. That's my opinion.
All right, with that, we're going to move on to our final segment of the night.
Man, it was good. I feel like it was good.
Our red
flag.
The judge.
Who was 2 people.
Interesting.
Tonight's red flag is one we found in our own research, not someone else's reporting.
When we first pulled the Lindsay Clancy docket, we hit a real discrepancy. The event grid listed the presiding judge as Gilda, but the docket's own narrative text said Sullivan.
We went with the narrative text as the more reliable of the 2 since it was more specific, but we flagged it as unresolved rather than guessing.
Since then, it's been resolved independently. The Boston Globe, CBS Boston, WBUR, and Boston.com all confirmed Judge William Sullivan is presiding over the Clancy trial.
So that's tonight's lesson. When your own primary source has an internal inconsistency, you don't pick the answer that sounds right, you flag it, and then keep checking until independent sources actually settle it. And I will say...
something I wish the justice system would do.
What I'm going to say on that matter is that you will hear me repeatedly say that I think that in terms of our legal system, there are a few very strong candidates for sourcing. For example, the docket itself.
Yes.
And we talked about the docket in another one of our episodes.
And
I can't
again,
remember.
Lacey talks about the docket all the time, but understand, yet while it is a very reliable source with the information that's in it, it is not all the information by any means whatsoever.
It is not, but it is what is submitted to the court.
Yes.
So, in theory, if a news place or magazine or social media or whatever is reporting that such and such was filed with the court, in theory,
it should be there.
It should be on the docket.
Yes.
So I should be able, unless...
and understand that it could be an interpretation,
etc. But again,
right.
You should not be interpreting.
No, but the media outlets, they interpret it.
Yes, we do headlines.
Mm-hmm. Yep. So, with that being said, checking the independent resources and the independent sources.
So again,
that's what we do here.
Yes, the whole thing. I start with the docket, okay, and I look at your specific case, and I look at your case number.
And then we look at the other
day.
reporting from it so that we can see, okay, what's being said about this.
And I just want to, let me be clear. When I say case number, so I am looking at your case number. I have a spreadsheet that I have created. And on my spreadsheet, it has the case, it has the parties, it has the county or what, district level the court is in, and I have the case number. And then I also have the website that takes me directly to that county, to that website. And I click on it, and I type in the case number, and I pull every day the docket, and I look, and I see what has been entered to the court. However, we've already discussed in some cases where the court system may not be quick. We've talked about weekends. We've talked about holidays. We've talked about it could be a very heavy case county where there's a lot of casework that has to be put in. And there is a court clerk that is inputting all of this information. I review that. And then I go and I say, well, this outlet is reporting this. That doesn't match what's in the docket. So then I pull another source and I say, well, this outlet is covering this. I tie it all back to what's already in the court record. Mm-hmm. However, when we start going to trial, there are some cases where and some counties, some court systems don't upload directly, such like, your PDF documents of the actual exhibits, things like that. The motions themselves, it'll just say, for instance, motion filed. It'll tell you who filed it. Each is different. Each docket system, each county, each state, all of those things are different.
Right.
And I'm not trying to tell people that they need to go out and pull dockets for every case that's in the news every day. But if you feel like something is...
if you're questioning it...
yeah, pull it. Yeah. Look at it.
Before we close tonight, we're going to recap some of the segments we talked about tonight, the new format, because it is very new.
Yeah, it was started on Friday's episode, which was episode 9.
And in our first segment, we covered...
the trial watch.
The trial watch. I got to find my mouse.
And
I need to make it bigger.
And I will say the trial watch is a segment that we will continue. Right now, we are covering the Lindsay Clancy trial, and that will continue throughout the course of her trial. And if there's any kind of post-trial things in regard to like movement with the case specifically. So any appeals or anything like that.
And stuff.
Yeah, we'll follow that. However, once her trial is concluded, we will find another trial.
Yep. And after trial watch,
Was the legal segment 2 legal minute?
That's it. Where we gave some legal jargon to you.
What an opening statement actually is and what it isn't.
And after segment 2, we moved on to the evidence of the night. We did talk about Kohberger and the fact that he is rescinding or wanting to rescind his guilty plea in a way that's not necessarily like a formal appeal.
Which I think is interesting.
Yeah, but he's
itself.
representing himself. And then finally, after evidence of the night, we hit our red flag segment.
Which is segment 4.
Your own source contradicts itself. You flag it and keep checking. All right, with that, this has been The Particulars. Headlines end, the details begin.
We'll see you Wednesday. Follow, share, and find everything else. Schedule, merch, coffee at our Linktree. Our opinion.
Our analysis.
Not legal advice. Thank
you for walking the cases with us.
We'll see you Wednesday.